So the issue of concealed carry bans was once again granted, vacated, and remanded by the Supreme Court back down to a circuit court for them to stop defying what the Supreme Court said and finally issue a proper decision. But now it seems like that same circuit court is still engaging in shenanigans and things just got even worse. So let's break down what just happened. Now, as I mentioned in the intro, in this video, we're going to be discussing some new defiance that's going on the issue of concealed carry bans out of the state of New York. You may recall that recently 5 cases had expedited hearings before the Second Circuit because of recent warnings that were issued by the Supreme Court to the Second Circuit. Now, those 5 cases challenged various aspects of New York's new Concealed Carry Improvement Act, which was the CCIA, their new concealed carry law that they put in place just 8 days after the Supreme Court issued Bruen. New York and the Second Circuit continued to defy the express decision that was issued by the Supreme Court, and that caused a situation where GOA recently once again went to the Supreme Court for a re-review of their anti-York case, and once again, ultimately what the Supreme Court decided to do was grant, vacate, and remand the lower court's decision back down to the Second Circuit for a new decision in light of their recent Rahimi decision. Now, earlier this month, we got an order from the Second Circuit that acknowledged, yes, they needed to re-review the anti-York case and some of these other concealed carry cases out of New York in light of the Rahimi case, because again, the Supreme Court GVR'd all those issues. But now we just received an order from the Second Circuit that said that no, they are only going to review the anti-York case. They are not going to review any of the other New York concealed carry cases that were pending in front of them, that were kind of reviewed at the same time, consolidated prior and ruled on prior. They're not going to re-review those other cases in light of Rahimi. Instead, they are now trying to say that the Supreme Court only granted, vacated, and remanded anti-York, and that's all they have to look at. Now, some background on what happened and how these cases are now back in the hands of the Second Circuit and why this really matters as far as the Second Circuit trying to duck new review of all these other cases. You may recall that in Bruen, the Supreme Court struck down New York's original May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. However, despite that new Bruen decision, New York rushed through the new law there, the Concealed Carry Improvement Act, which was a new permit scheme even worse than the one that existed prior to Bruen, and they passed that just 8 days after Bruen, and there expressly the state of New York said that they were doing it pretty much in direct defiance to what the Supreme Court just ruled. This new concealed carry law was challenged in multiple cases, and multiple district courts ultimately reviewed and some granted preliminary injunctions which halted the enforcement of the CCIA. However, the state of New York appealed that decision up to the Second Circuit, who then granted blanket stays on all of those decisions. Now, that led GOA for the first time to go to the Supreme Court about a year ago on an emergency basis. Now, the Supreme Court on review denied the emergency applications. They did not want to get involved early on a preliminary injunction. They didn't want to get involved at that time, but they did identify to the Second Circuit that the Second Circuit could not simply drag their feet on this issue. They would need to properly address it. And that essentially led to the Second Circuit having to review expedited hearings on all of these CCIA cases. All these CCIA cases, I think it was about 6 of them, were then consolidated, heard, argued, and then ultimately decided together. Now, in their decision, the Second Circuit distinguished Bruen as an exceptional case. What they said is Bruen was an exceptional issue. It dealt with an exceptional law. They tried to say that here the CCIA and this new concealed carry law in New York is not exceptional, and because it's not exceptional, essentially the state of New York could do whatever they want and put whatever restrictions they want in place. Now, in response to those Second Circuit rulings, what ended up happening is GOA then filed a petition for Supreme Court review, and this was the second time that GOA went to the Supreme Court. Now, although the case was still in an interlocutory posture, it was important because it dealt directly with Bruen, with that decision, and New York's response directly to what Bruen said in this new law that they put in place. Also, the fact that the Supreme Court had prior stated that there is a potential for reconsideration if the Second Circuit did not handle things appropriately led to more strong evidence that the Supreme Court would get involved even at an interlocutory posture. So that petition was pending in front of the Supreme Court. Now, ultimately, what ended up happening is the anti-York case was put on hold, and it was held behind the Rahimi case. And Rahimi was a challenge to some Second Amendment laws that are in place at a federal level, essentially possession restrictions for individuals who are subject to domestic violence restraining orders where they cannot possess firearms, ammunition, and other items. Ultimately, like we all know, the Supreme Court did issue a new decision. It was an 8-1 decision, essentially upholding that aspect of the federal law, specifically as applied to that one individual, Mr. Rahimi. And there was some other language in the Rahimi decision that was pretty much applying the analysis in Bruen. It was a very narrow decision. There was a dissent from Justice Thomas where he wanted the approach to still be even narrower under Bruen, talking about some of the historical analogs and the more nuanced approach. But ultimately, the Supreme Court did issue that Rahimi decision. And then a lot of questions were out there about, okay, what's going to happen with Antonyuk because it was put on hold behind Rahimi. And what the Supreme Court ultimately decided to do was grant, vacate, and remand the Antonyuk case back down to the Second Circuit for a new decision in light of Rahimi. So the Second Circuit was directed to re-review this issue, and then this case was opened back up in the Second Circuit last month. And then we got an order from the Second Circuit, and it stated that it is hereby ordered that the parties shall submit supplemental briefing on the issue of how the United States versus Rahimi case affects the judgment of this court rendered on December 8th, 2023. So the Second Circuit opened the case back up and requested supplemental briefs from all the parties. Now, like I mentioned prior, when the Antonyuk decision was issued by the Second Circuit, it wasn't just in that isolated case. The Second Circuit reviewed multiple cases that were challenges to various aspects of the CCIA. You had cases like Antonyuk, the Spencer case, the Hardaway case, the Christensen case, and all of those dealt with different aspects. Like I mentioned, Antonyuk was a broader challenge, more comprehensively to the CCIA. But then you had some of the other cases that challenged more narrowly aspects like concealed carry restrictions in places of worship, and then some other public restrictions on sensitive locations like parks and other things like that. So some of the cases were a little bit more narrow in the sensitive locations that they were challenging. Antonyuk was a little bit broader where it challenged the concealed carry process, the catch-all provisions where you would have to get permission from a business to actually carry. So Antonyuk was broader, like I mentioned, but you still had all those other cases that were reviewed, heard, and decided altogether by the Second Circuit. And originally what the Second Circuit said is that they were opening review to all of those cases once again. They were going to potentially hold hearings in all of those cases again. They wanted supplemental briefs in light of Rahimi in all of those cases. But then we just received a new order from the Second Circuit. And the new order from the Second Circuit said that upon due consideration, it is hereby ordered that the August 7th, 2024 orders recalling the mandates in Hardaway, Christensen, and Spencer and directing the parties to submit supplemental briefing is vacated. And the mandate in each of those three cases is reinstated. As only the plaintiffs' appellees in Antonyuk petitioned for and were granted a writ of cert from the Supreme Court in August 5th, 2024's judgment must be reasonably construed as limited to the parties in that case and did not require the recall of the mandates in Hardaway, Christensen, and Spencer. Accordingly, the August 7th, 2024 orders in Antonyuk remain in effect. So what does that mean? You may be asking, why is that important? Well, again, this is the Second Circuit trying to limit damage as much as possible. Originally, when the Supreme Court granted, vacated, and remanded Antonyuk, what the Second Circuit initially took that as was that they needed to redecide and re-review all of these CCIA challenges, all of those cases that they had prior consolidated and ruled on. But then, upon further analysis, they say on their own consideration, they decided that no, the Supreme Court only GVR'd Antonyuk. That was the only petition from the Supreme Court. So they are not going to open up new review of all the other cases. Instead, they are only going to proceed forward with Antonyuk. They're only going to re-review Antonyuk, and they're only going to require additional briefings in light of Rahimi in that one case. But no surprise, once again, the Second Circuit and some of these lower courts are still engaging in their gamemanship and directly defying the Supreme Court, and they do not want to actually approach these Second Amendment cases appropriately. They don't want to properly apply Bruen and now even Rahimi. So we're going to see how this plays out going forward, and now supplemental briefs will move forward in the one case Antonyuk. And I also wouldn't be surprised if you see some additional filings in all these other cases, maybe even going to the Supreme Court, seeking additional clarification on whether or not that GVR should also apply to their cases and whether or not the Second Circuit should also have to re-review their cases in light of Rahimi. So if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.